So there are four main gaps that I often found in the field. The first will be the non-compliance of employment contract. So Indonesian labor laws and regulations already prescribe the minimum clauses that mandatory to be provided under employment contract. If you miss some or one of the clauses, it can effectively affecting your employment relationship. For instance, if you have a non-permanent employees and you're hiring them under a non-permanent employment contract, but you miss some clauses, this employee can claim that, well, your employment contract is not enforceable, so by the end of the day, I'm actually a permanent employee, and we don't want that, right? Second, it would be the underpayment of overtime money. So again, Indonesia has regulated about the formula on how to calculate overtime money. The formula sometimes are correctly used, but things can become an issue when the salary component is consisting not only basic salary, but also fixed allowance. Because I often found that employers tend to disqualify or excluding this fixed allowance component when they want to calculate the overtime money. And because of that, it's resulting in underpayment. Third gap, I would say the overuse of non-permanent employment contracts. So again, as I mentioned, the maximum total period the employer can utilize non-permanent employment contract is 5 years. But unfortunately, in practice, I've found many employers that hiring, that engaging employees in Indonesia for more than 10, even 12, 15 years, but still through non-permanent employment contracts. Of course, this is illegal, and once you found there's such issue, it will continue to another different 10 issues like the social security registration and so on. The number 4 gap will be the non-existence of company regulation. So in Indonesia, when you are hiring or you're employing 10 employees or more, you must have what we call company regulations. It's basically employee handbook, where some things that are not fully regulated under the employment contract, it needs to be stipulated in the company regulations. It also needs to be registered and legalized by the labor office. Otherwise, as an employer, the company may be subjected to several sanctions, including administrative sanction and criminal sanction.